CALTEX Philippines Incorporated versus the Intermediate Appellate Court and Asia Pacific Airways Incorporated, GR number 72703, November 13, 1992. The topic: Payment of Interests. The facts of the case: Respondent Asia Pacific Airways Incorporated entered into an agreement with petitioner CALTEX Philippines Incorporated, whereby petitioner agreed to supply private respondents' aviation fuel requirements for 2 years. Respondent had an outstanding obligation to petitioner in the total amount of 4,072,682 pesos and 13 centavos. A deed of assignment was executed in favor of petitioner and assigned to petitioner its receivables or refunds of special fund import payments from National Treasury of the Philippines as payment. Respondent learned that the amount remitted to petitioner exceeded the amount covered by the deed of assignment and requested a refund of 900,000 pesos and also demanded the refund of the remaining amount. Petitioner informed private respondent that the amount not returned, amounting to 510,550 pesos and 63 centavos, represented interest and service charges at the rate of 18% per annum on the unpaid and overdue account of respondent. The issue: whether or not the deed of assignment entered into constituted dación in pago so that petitioner was not legally authorized to deduct the amount for interest and service charges on the unpaid and overdue accounts of private respondent. The ruling: the deed of assignment executed by the parties is not a dación in payment and did not totally extinguish respondent's obligation. The obligation is totally extinguished only when the parties, by agreement, expressed or implied, or by their silence, consider the thing as equivalent to the obligation. In order to judge the intention of the contracting parties, contemporaneous and subsequent act shall be principally considered under Article 1253 Civil Code. The foregoing subsequent acts of the parties clearly show that they did not intend the deed of assignment to have the effect of totally extinguishing the obligations of private respondent without payment of the applicable interest charges on the overdue account. Finally, the payment of applicable interest charges on overdue account, separate from the principal obligation of 4,072,682 pesos and 13 centavos, was expressly stipulated in the deed of assignment. The law provides that if the debt produces interest, payment of the principal shall not be deemed to have been made until the interest have been covered. CALTEX Philippines Incorporated versus the Intermediate Appellate Court.